Hello class, this video will take us through the civil case procedures. Civil cases follow 7 steps. The first is the pretrial hearing, second is the jury selection, third, arguments and evidence, fourth, jury instruction, fifth, verdict and judgment, 6, remedies, 7, execution of judgment. After these 7 steps, there is an appeal process. We're going to go through each of these 7 steps as well as the appeals process so that you understand how civil cases proceed through the judicial system. So before any case ever goes to actual trial, it moves through a pre-trial process. So these cases have not gone into the traditional courtroom at this point. Okay, now remember, these are civil cases. No one has been arrested at this point. These are disputes between 2 individual parties. Okay, so if 2 people have a dispute and they can't resolve it outside of the courtroom, they'll go to trial. But no crimes have been committed at this point. So in the pretrial, the first step, how things get started, okay, the plaintiff or the person who has the complaint, okay, and wants to take the dispute to court, they're going to go to the courthouse and they're going to file papers, okay, and they're going to describe their claims against the defendant or the reason that the dispute exists in the first place. What do they want the defendant to do, or what do they want the defendant to stop doing, and why do they need to take them to court in order to get that done? So the second step in the pretrial, after the initial papers are filed, there's going to be a period of discovery. And this is where the plaintiff's attorney and the defendant's attorney, they're going to go around and they're going to gather facts, okay? Things that they can use in the courtroom to prove their point, to make their case. Discovery, some of the evidence that's collected could be depositions. That's a legal term for interviews. There could be requests for documents that can come in a wide variety of different types of requests. There could even be physical or mental examinations. If somebody says that they were harmed, well, how do we take we can't just take their word for it. We're going to want a medical doctor to say that they actually had a physical injury. Or maybe somebody says that they can't do something because of their mental state. Well, we want to prove that. The attorneys are going to have registered licensed doctors make those decisions. After the discovery, the court clerk is going to place the case on the calendar or the docket. The docket is just sort of a legal term for a calendar. So after that discovery, the case gets put on the calendar, and then even before we go to trial, okay, there's going to be this initial hearing with a judge. Okay, some cases stop here and they're settled. Maybe during the discovery, one side decided that they didn't like their case and they want to try to come to an agreement before they go into the courtroom. Okay, if the parties cannot settle during this pre-trial hearing, then we go to an actual trial. So the next step is jury selection. Now it's important to point out that not every single case that goes to court has a jury, okay? That's determined in the pre-trial hearing. When it is determined that there's going to be jury members, okay, and I guess I should explain, jury means that there is a group of citizens that come, and the citizens are going to decide whether somebody was guilty or not guilty, okay? So remember, we're still talking about civil cases here. Now, if a jury trial is requested and it's agreed upon, then the jury or the judge is going to go out and they're going to request jury from people, okay? And that's called jury duty. That's when you get called to come to the court and serve on a jury. Okay, the lawyers, they're going to question the members of the jury about their background, their education, their experience, their relationships, attitudes, and employment. Okay, the lawyers or the attorneys, they're trying to figure out, and they're sort of, they're bargaining between the attorneys and lawyers on the other side about who are the people that are going to sit on this jury and make the final decision. You want to know because people are influenced by those things like their background, their education, their experience, and so on. Finally, okay, the parties will deliberate and bargain over who will sit on the jury. That's what we just talked about. The attorneys and lawyers, they're going to go back and forth. They're going to, they're going to try to make their picks. And they're going to go back and forth in its whole process on who is going to sit at that jury. What I want you to remember is don't just think that, a certain number of people are selected to sit on this jury, and then that's it. There's an exchange. There's a back and forth before they have that final decision who sits on the jury. Okay, now we've come to the arguments and evidence, and this is really the heart of a trial. Okay, this is what you see in the movies. This is when the lawyers are up there. This is when we have witnesses. This is when we have testimony. Okay, so this is sort of the big picture Hollywood movie type of trial that a lot of people are used to seeing, the arguments and evidence. So first off, each lawyer, both the plaintiff and the defendant, okay, those are our two sides of a civil case, they're going to make their opening statements. In those opening statements, they're going to say what I intend to prove. Okay, they're going to make their case as to why their side is right. The prosecution always goes first. Okay, the plaintiff, the person that's bringing the complaint, they're the ones that are going to start things off. The defendant is always going to have the last word. Okay, the plaintiff's lawyer, they're going to present their case. So this is step number 2. The person that's bringing the complaint, they're going to go first. They're going to bring forward their witnesses. They're going to bring forward expert opinions. So these are experts in different fields like medicine or finance, and they're going to bring those people up and have them testify as to why their side is right. Okay, there's going to also could be physical evidence. Okay, the defendant's lawyer, they're going to get their chance then to cross-examine. Okay, cross-examine means that they get to ask questions to the individuals that the plaintiff brought to the stand originally. Okay, they're going to cross-examine the plaintiff's witnesses from bullet point number 2 to test the truth of statements. They're going to try to get the plaintiff's witnesses to slip up. They're going to try to get them caught in, a lie, or maybe a half-truth, or maybe, they don't remember something correctly when under cross-examination. The defendant's lawyer is trying to get the jury to question the reliability of those witnesses. Did they really remember seeing something? Do they really remember the time of day that they saw something? It's little things. They're trying to break down their credibility or their believability. Okay, this fourth bullet point, the defendant will then present their case. Okay, so now the plaintiffs are done. Now it's up to the defendant to present their case as to why the plaintiff's claim, why they shouldn't be in court in the first place. Okay, then just like the defendant can cross-examine the plaintiff's witnesses, so too can the plaintiff cross-examine the defendant's witnesses. Okay, so it's 2 steps, and it's vice versa in both ways. Okay, so step number 1, the plaintiff's witnesses go, then the defendants will cross-examine those plaintiff witnesses, and then the defendant will bring their witnesses, and then the plaintiff will get to cross-examine the defendant's witnesses. Finally, there's going to be the closing statement. So this is, the conclusion, the summary. Both sides are going to give their summary of what they believe happened, and then they're going to suggest to the jury why they should find guilt or innocence. Okay, once again, the plaintiff or the prosecutor, they're going to go first. Then the defendant will always have the last say. So after arguments and evidence, we go to jury instruction. Now here the judge is going to explain the laws, okay, what the law actually says related to the case that they just listened to. Okay, and he's going to explain it to the jury so that they are crystal clear on what they are trying to hold these parties accountable to. Okay, then the jury will go and they'll deliberate, and they go and they meet by themselves. During this deliberation, they're trying to determine whether they're going to agree with the plaintiff or the defendant on the verdict. Okay, and the verdict is the result of the case, whether or not the defendant is found guilty or innocent, or what they have to do in order to resolve the dispute. It's up to the jury to determine whether or not they believe the defendant violated the laws of the case. It's in the jury's hands at that point. There's nothing that the plaintiff or the defendant or the judge or the attorneys can do at this point. Now for civil cases, the jury does not need to be unanimous. So that means that you can have people that may disagree with the majority of the other jury members. What you need is, if there's a jury of 6 members, 5 of them have to agree on the verdict. 5 of them have to say the same thing as to whether the defendant is innocent or guilty. And then if we have a jury made up of 12 members, then you only need 10 of them to be in agreement. After the jury deliberation, things move along very quickly. Okay, so once the jury has come to their decision as to innocence or guilt, they're going to go ahead and they're going to give they're going to deliver the verdict to the judge. Remember, the verdict is the ruling in the case. The judge is going to read the verdict to the plaintiff and the defendant, and that's when they're going to know whether the defendant is innocent or guilty. Third point, the judge will give a judgment. Okay, this judgment is what the court determines the liability is in the case. What type of punishment is the defendant going to, receive? What are they going to have to do to make things right? And that's in an instance of guilt. Now, if there's innocence, then the defendant doesn't have to do anything. Okay, remember, these are civil cases. People don't go to jail in civil cases. People go to jail in criminal cases, and that's what we're going to be looking at in our next lesson. But I really want you to remember, there is no jail time with these types of civil cases. The remedies are typically going to be money. Okay, and then if there is no jury, the judge is going to deliver the verdict in the case. If there's no jury, then it's up to the judge to determine whether or not the plaintiff or if the defendant is innocent or guilty. So like I was saying on the previous slide, okay, we don't have jail time in civil cases. Okay, if that defendant is found to be guilty, the court will provide the plaintiff a remedy. Okay, that remedy is a solution to the dispute that they came to court to resolve in the first place. But that does not mean jail time for the defendant. There's 3 types of remedies. Okay, the defendant will pay the plaintiff money. That's the most common. The second one we call specific performance. That means that the defendant has to do a particular action. Third is an injunction, and it's sort of the opposite of specific performance. In an injunction, the defendant just has to stop doing a particular action. Okay, so if there is, if my next door neighbor takes me to court, okay, because he says that I play loud music every night into the really early hours of the morning, like 3 a.m., day in and day out, well, maybe he's going to take me to court over that. Okay, and the court may say that, they're going to file an injunction against me and I need to stop doing that particular action, okay, playing loud music. So those are the 3 remedies for civil cases. Now, after the judge has given the judgment, okay, or, remember the judgment is what the defendant will have to do if there is a verdict of guilt. Okay, now we need to execute it, or we need to carry it out. Okay, it's up to the court to ensure that a judgment is carried out. Okay, the judge will issue an execution order. So the example I have here, the judge is going to order the local sheriff to take a defendant's property to sell at auction to pay the judgment ordered to the plaintiff. So maybe the plaintiff says that the defendant owes him money for one reason or another, and the judgment comes down that, yeah, the defendant does need to pay the plaintiff maybe $1,000, but the defendant doesn't have $1,000, but he has a used car that's worth $1,500. Well, the judge may say to the sheriff, okay, you're going to go take that car from the defendant and you're going to go sell it at auction, and then the $1,500 that it gets at auction, $1,000 of it will go back to the plaintiff, and then the defendant will be left with the remaining $500. Okay, that's the court carrying out the judgment. All right, finally, we're at the appeals process. So either party, either the defendant or the plaintiff, they can appeal a court's judgment. And these appeals mean that they're going to take it up the ladder. They're going to take it to a higher court to maybe see if there were any legal mistakes made by the judge. Now, this is not a retrial, okay? They're not bringing in new evidence. They're not bringing in new witnesses and things like that. We're not going through a whole discovery period. Okay, all they're trying to figure out, was there a mistake in the lower court's processes or their judgment? Okay, and then there are 3 ways that this can play out. The appeals court can affirm, okay, and that means that they agree with what the lower court did. They can reverse, meaning that they disagree with the lower court, or they can remand it, and that means that they send it back to retrial at a lower court. In that retrial, then new evidence can be admitted or new witnesses can come, and you kind of start all over again when you have that retrial. Okay, so this concludes our discussion of the civil court procedures.